Just a little bit about AFTINET. We're a network of community organisations campaigning for trade justice. We have a wide range of environment unions, faith, aid and development, public health, human rights and other organisations. And we campaign for enforceable environmental commitments in trade deals and against corporate rights to sue governments for if they have environmental and other public interest regulations. And we have links with other national and international trade justice movements like PANG and organisations in New Zealand. And our website is there. So what is ISDS and why do we oppose it? So all trade agreements have state-to-state dispute processes, which are special, but only some agreements have special legal rights for corporate investors to sue governments. So investor-state dispute settlement, or ISDS, enables international investors to claim billions in compensation from government for government changes in law or policy which affect their future profits, even if the change protects health or the environment. The claims are heard by international tribunals. ISDS began under post-World War II decolonisation and was designed to compensate former colonial investors for nationalisation or taking of actual property by newly independent states, like when Egypt nationalised the Suez Canal. But it has grown and developed over 60 years with concepts like indirect expropriation and legitimate expectations, which don't involve taking of property, but they're about changes in law or policy. There's now over 2,000 agreements and 1,463 known cases, mostly in global south countries. And these international tribunals don't have the safeguards of national legal systems. They're held in secret. There are no independent judges. The arbitrators can continue to practice as advocates, and they don't have precedents or appeals, and they don't have consistent decisions. And what has happened is that fossil fuel companies are increasingly using ISDS to claim billions for government climate action with chilling effects on other governments. And of course, the worst example we have in Australia is of Australian billionaire Clive Palmer, who registered his mining company in Singapore and claimed to be a Singapore investor. And he's using ISDS rules in Australian trade agreements with Singapore, in an agreement with ASEAN and New Zealand, to sue Australia for a total of $120 billion in compensation from the federal government because community campaigning led to a Queensland court decision which denied him coal mining and energy licenses for environmental reasons, including their contribution to carbon emissions. He had a separate earlier claim of $300 billion for a commercial dispute with the Western Australian government over an iron ore mining licence, which he lost in the High Court and then bypassed that and went to the International Tribunal. And that means his total claims are $420 billion, which is an eye-watering amount of money. The government has already spent $13.6 million on legal fees for the first claim, which actually the tribunal found that Palmer was not a Singaporean investor. However, Palmer has objected to this decision on technical grounds, and the last three coal-related cases are still continuing, which means the government, he's maximising the time and the costs to government. So Palmer's coal cases join a growing list of fossil fuel companies using ISDS against climate action. There are many claims of US and Canadian fossil fuel companies against environmental regulation in Central and South America. Australian billionaire Gina Rinehart's company is suing Canada over a refusal of a coal mine permit in a sensitive environmental area. ExxonMobil and UK Shell have cases against the Netherlands because they closed hazardous gas fields, and the Singapore Woodside Company has a case against the UK because their High Court refused a coal mine licence. So that's just happened in the last 12 to 18 months, those three cases. So these cases are continuing. A UN 2025 climate finance report said that ISDS was a barrier to climate action, and these ISDS corporate rights clash with the July 2025 International Court of Justice advisory opinion that said that states have legal obligations to review laws and treaties that undermine UN climate agreements. So in Australia, we are campaigning for Australia and other countries to take stronger action against ISDS in the context of the COP processes, and Australia being the president of the UN COP COP 31 negotiations. And this has arisen because Labor in office, partly because of their experience of being sued by the Philip Morris Tobacco Company over our plain packaging law, does have a policy prompted by community campaigning of no ISDS in new agreements and to review and remove it from existing agreements, both in Global North, with Global North and Global South countries. The current Labor government has excluded ISDS in new agreements, but the review process is a slow process. So there are 25 agreements, 10 with ISDS, and 13 are currently being reviewed. So the ISDS claims are increasing rapidly, as I said, and we believe more urgent action is needed. And we're trying to get Australia to join with others in more collective withdrawals from ISDS. And you can see our campaign material on that link, which I think Alex is going to put into the chat. So our next speaker is Dr. Kyla Tienhaara from Queen's University, Kingston in Canada, who was at Santa Marta and is going to summarise the experience and outcomes of the conference. So over to you, Kyla.
Thanks so much, Pat, for the invitation to be here. I would also like to acknowledge the Kaurna people as the traditional custodians of the Adelaide region, which is where I'm speaking from today. So as Pat said, I attended the first conference on transitioning away from fossil fuels in Santa Marta, Colombia in April, and I also helped to organize a work stream that focused on ISDS in the academic conference. So I'm here to provide you with some reflections on my experience there. I assume most of you know what the Santa Marta conference was about, and I don't really have time to get into the whole backstory of it. But basically, it was intended to tackle the question of how, not if, to phase out fossil fuels. And notably, it was a forum for open discussion rather than negotiation. But the hope is that the process that was set up in Santa Marta may eventually lead to a fossil fuel treaty among a sort of coalition of the willing. So with that context, I would like to note that I was initially not very keen to go to Santa Marta, not because I didn't think it was going to be an important meeting or that it wouldn't be incredibly interesting, but simply because I didn't want to spend the 40 or so hours on planes and in airports that it would take for me to get from Adelaide to Santa Marta. So this shot was taken very early in the journey as I was leaving Sydney on my way to a layover in Santiago de Chile. And I think at this point I was thinking, what am I doing leaving this beautiful landscape to go so far away? But what actually inspired me to make that journey was something that's seemingly quite mundane. It was this part of the conference website. So it may not look like much to the casual observer, but for someone who has worked on ISDS for over 20 years and has had to spend so much time just explaining to people what I do and why I do it, to see ISDS named as a key barrier to the energy transition by governments, or at least one government, because I actually don't know whether Colombia consulted anyone before putting ISDS on the agenda, this felt really momentous. And I think that's the reason why so many ISDS experts actually attended the conference. We felt, first of all, that it was an opportunity to really try to shift the discourse on the debate, but we also wanted to support Colombia and back up their decision to put this on the agenda, which could not have been an easy thing to do especially because the co-host for the conference, the Netherlands, is second only to the United States in the list of states that are the home of the most investors bringing ISDS claims. So in other words, Netherlands treaties are very frequently invoked in ISDS. So what would have inspired Colombia to highlight ISDS at this conference? Primarily, I think it's a combination of the country's experience with it. They've been sued at least 29 times, which makes them rank quite high on the list of sued countries. And also the fact that the government's ambitions for a just transition are being hampered by the fact that a significant amount of fossil fuels in the country are protected by investment treaties. So Pat has already discussed some of the climate and ISDS cases. I just want to give you one example of a case from Colombia. This is an ongoing case that involves the Swiss mining giant Glencore, which owns and operates Cerrillon, which is the Latin America's largest open pit coal mine, also one of the world's biggest. There have been horrible impacts from this mine for the local communities in the area, which is a few hours north of Santa Marta. These are primarily indigenous and Afro-descendant communities. There's some that have been displaced by the mine. There have been huge issues with water, which is scarce in the region, and the mine has actually diverted a number of rivers. This is a photo that I took when I was visiting one of the communities after the Santa Marta conference. So Glencore had wanted to expand the mine even further, and this involved more diversion of watercourses. And so the communities challenged this in the courts, and the Constitutional Court, the highest court, eventually ruled that the expansion should be halted so that further studies could be conducted on the impact of the water diversions. This temporary suspension led to Glencore suing Colombia for $489 million. And this, if you'll notice in the title, it has a brackets 3. There's actually 4 cases that have been brought by Glencore against Colombia over the past decade. So this experience has made the government increasingly unhappy with the ISDS system. And recognizing this, as well as the important role that Colombia was playing in co-hosting the conference in Santa Marta, a group basically started a campaign to get the current leftist president, Gustavo Petro, to quit the system before he leaves office later this year. There was an open letter in March with 220 signatures from legal experts and economists, including Nobel laureate Joseph Stiglitz, that was sent to Petro, and he responded almost immediately with a pledge to get out of ISDS. So that was a really great moment, especially as it was just a few weeks before the conference in Santa Marta. The actual mechanics of Colombia getting out of ISDS are a bit more complicated, especially because there are presidential elections. I think the first round of those elections is actually this Sunday, so something to keep an eye on. So that gives you a better understanding of why Colombia put ISDS on the agenda in Santa Marta and why so many of us were keen to be there. But what did we actually do when we got there? Well, first of all, I think it's important to note that there were many different things happening in Santa Marta over the course of nearly a week, from the 24th to the 29th of April. And these various events brought different groups together. So the first major event to happen was the academic pre-conference, and that was the main thing that I was in Santa Marta to participate in. We had a dedicated work stream on ISDS, and about 30 or so people attended, not just from academia, but also think tanks, NGOs, lawyers, even some former government officials who had experience with ISDS in their countries. And basically, we just spent 2 days trying to hammer out what we wanted to recommend that governments in Santa Marta commit to. And the one point that we had broad consensus on was that we didn't want to advocate for reform of the investment treaty system. We wanted states to move away from it completely. And this is something that states have shown a willingness to do in various circumstances. And Pat told you about how Australia is moving away from the system as well. However, we were also very keenly aware of the fact that it is easier said than done to get out of ISDS. We're talking about over 2,500 treaties that contain ISDS provisions that states will have to either exit or substantially modify in the case of large trade agreements with investment provisions. And that's a lot to accomplish, particularly when governments have a lot on their plates. And while it is true that any country can unilaterally cancel an investment treaty, it is also true that many of them have these annoying little clauses called survival clauses, which mean that the treaty will continue to protect investments for 5 to 20 years after they're terminated. And that's really bad news if we're thinking about climate change in particular, because this is a time frame in which we need a lot of climate action to happen. But the good news is that if treaty partners can come to a mutual agreement to terminate, they can nullify those survival clauses. So that's one of the reasons why we're really focusing, as Pat said, on collective action, plurilateralism, getting groups of like-minded countries to come together to try to alter or cancel as many treaties as possible at once. So it was really these two ideas, get out of ISDS, but do it collectively, that were the basis for 5 recommendations that came out of our work stream that were then presented to governments along with the recommendations from 11 other groups at the academic conference. I don't have time to go through them in detail, but you can find them on the Santa Marta conference website. And I am also happy to talk about them more or answer questions about them in the Q&A. Now, as I said, the academic pre-conference was just one of many events happening. And so I also want to highlight the fact that the NGO chapter and the trade union chapter also put out statements that included strong references to ISDS. And importantly, the representative for trade unions spoke about ISDS in the very limited time, they only got 3 minutes, that they had to speak in the closing plenary of the high-level government meeting. The private sector roundtable, which was convened on this Fortescue ship that runs on ammonia and was anchored in the harbor, also mentioned ISDS. It wasn't a super helpful statement, as it talked about ISDS being a, quote, perceived barrier rather than an actual one, and there being a lack of evidence. But nevertheless, I do think that this statement could have been worse. And I think one of the reasons why it wasn't worse was because fossil fuel companies were not invited to Santa Marta, so they weren't at this roundtable to defend ISDS. Now, you may be wondering, what did governments do with all these recommendations that were submitted to them from different groups? Technically nothing. This was never a conference where commitments on anything were going to be made. So far, all we have that's come officially out is a co-host summary report, which was unfortunately quite weak on ISDS. It sort of talked about perceived barriers reflecting the private sector's position. But there was also this additional note about work streams for what was going to happen going forward. Here, ISDS is not explicitly named, but it was suggested by the Colombian government in sort of bilateral conversations that it would be addressed in the second work stream, which addresses finance. So overall, my key takeaways are that despite the lack of anything really concrete coming out of this conference, it was really an incredibly positive and inspiring experience. The amount that ISDS came up in conversations and discussions was remarkable, and it really seemed to suggest that a shift had occurred where this topic has moved from really being a niche one to much more mainstream. That being said, it was clear that while many delegates were concerned about ISDS, they also didn't feel like they had ownership of the issue because they're climate or environment officials, and ISDS is considered squarely within the domain of trade or economic ministries. How to overcome these kinds of policy silos, I think, is something that we're going to need to continue to work on. Also, I would say that I think it's possible that we would have gotten a different outcome, especially in the co-host summary, if Netherlands had not been the co-host. They were seen as playing kind of a blocking role. Colombia was the key champion on ISDS, but there certainly were other countries that were supportive, and I would include the Pacific country representatives that we met with here. Which leads us to the question of what comes next. So there are certainly opportunities in Bonn at the Pacific pre-COP and at COP itself to continue the momentum on ISDS and climate discussions. But also, in addition, we do have another conference on transitioning away from fossil fuels, which it was announced will be held in Tuvalu in early 2027. The co-host for that conference will be Ireland. Neither Tuvalu nor Ireland really has much of a stake in the ISDS system. They don't have any bilateral investment treaties, but notably, Ireland does have some very recent experience in being sued by oil and gas companies under the Energy Charter Treaty, which is a treaty that they announced they would leave while the Santa Marta conference was ongoing. So Adam is actually going to talk more about ISDS in the context of the Pacific. So I think I will leave it there and turn it over to him. Thank you.
Thanks very much, Kyla. Um, so I'll now like to introduce Adam. Um, Adam Wolfenden, our next speaker, is the Deputy Coordinator for the Pacific Network on Globalisation, or PANG. So over to you, Adam.
Great. Uh, Thanks so much, Pat and AFTINET for organizing this. I'd also just want to note that I'm speaking to you today on the unceded lands of the Awabakal and Worimi people, acknowledging that their sovereignty was never ceded. And, I think this is an important point to start, this conversation around ISDS in terms of, the loss of sovereignty that already exists in these countries and the way these structures like ISDS sort of exacerbate and often harm Indigenous peoples, which I'm sure India will go into much more detail. As Pat mentioned, I work with the Pacific Network on Globalisation, PANG. It's based out of Suva in Fiji, and we've been working on trade issues for 25 years now across the region, as well as a number of other topics around decolonization, resource grabbing through deep sea mining, and a whole bunch of other issues. And ISDS is one of those topics that sort of cuts through a lot of that. And, listening to both Pat and Kyla's presentations, you can see the reason why, because it circumvents a lot of national laws that are often hard fought for and won. So what I want to talk about today is just how ISDS is impacting and connected to the Pacific. As was mentioned by Kyla, there is some a number of Pacific Island countries that have investor agreements with ISDS in them. Some of these are in effect, some of them have just been signed. You can see that they're, Papua New Guinea, Vanuatu, Tonga, Fiji, and RMI. And so it's a bit of a patchwork in terms of what isn't in effect. There's a number of agreements that we don't know exactly is involved because there's no text available. And it's also important to realize that a lot of these agreements were signed back in the 80s and 90s. So they're very much from a time, like Pat was sort of alluded to, a very they're not very contemporary. They don't respond to the moment and the challenges that governments are facing now, but they have these legacy effects that still prevent and sort of inhibit the way that governments can regulate, particularly in response to threats like climate change and others. But as you can see, for the Pacific, the exposure isn't as, I think, wide as a lot of other countries, but as I'll sort of cover, the impacts both through these investment treaties, but also through private commercial contracts, is just as damaging. So when we look at ISDS in the Pacific, the one main example that sort of popped up is around Papua New Guinea and the Porgera mine. And this basically starts back in 2020, where the extension of the mining lease was knocked back by the Papua New Guinean government, which sparked Barrick Gold, one of the key investors in the local, the PNG based company, starting to initiate the process of an ISDS claim. And to do that, again, similar to Clive Palmer, they sort of had to shop it around a bit to find the right forum to do that, which in this case it was through the Australia Papua New Guinea bilateral investment treaty. And we also see that because PNG has an agreement with China, there was also a role there for a Chinese company that was also a part owner to kind of use the refusal to renew the lease as a potentially impacting the political relationship that China and Papua New Guinea have. And so we see these issues around ISDS as being leverage points, both from a either the threat of having to pay millions and millions of dollars, which countries may not have, to also the political ramifications of what might come if certain decisions aren't made. The Porgera mine itself was quite controversial. There was a long history of human rights abuses, environmental contamination. So there was a big push by local groups and others to not extend the lease of the mine for very good reasons. And when it all came down to it, the threat of the ISDS case, the pressure from other parties, ended up seeing a new lease given for the mine, which the Papua New Guinea government claimed was, on better terms. It was a more joint venture. There'd be greater benefits flowing back to the communities. They sold it as a big win, but a lot of critics are saying actually it was really the threat of ISDS that forced their hand on this. And so, you start to see it happen throughout the Pacific as well as a lot of other countries around the world. So the Pacific is definitely not immune from it happening within those bilateral investment treaty frameworks. But one of the other avenues that we're starting to see come into the region is through deep sea mining contracts. And so these are private companies making contracts with governments, in this case, Tonga and Nauru. And this is, coming with the promise of, sharing, like profit sharing. But the text of what we're seeing within these contracts is, grossly weighted towards the interests of the private company, which is in this case called the Metals Company. And this is becoming a bigger issue because deep sea mining is intricately linked to climate change responses. It's both being sold as a solution, which we would claim is a false solution, because a lot of what the impacts of deep sea mining will be, we don't know, but we do know that they'll be effectively permanent. It will disrupt the carbon sinks of the ocean. So whilst being sold as like generating resourcing for a green transition, it will actually really quite heavily disrupt the natural carbon sequestering processes of the ocean, which completely defeats the purpose. But what we're seeing through the contracts, and I'll just list some of the main features here to sort of highlight how problematic they are, is that they, the first thing is, so a lot of, similar to the ISDS process under an investment treaty, it allows any conflict between the investor and Tonga or Nauru to be taken to Singapore for to be heard under the sort of jurisdiction of Singapore in these sort of very pro-investor jurisdictions and courts. So the first problem with this contract that we've seen is that it basically sits above any new law. The way it's written is that it has to abide by the Seabed Minerals Act of 2020 in Tonga, but otherwise, if there's any new law or legislation passed, if it undermines the rights already given to the investor, then this contract supersedes that law, which is an enormously we talk about advocating for self-determination and these sorts of things. This is a massive concession to a private company of a government's right to regulate. The second issue is around this term fair and equitable treatment. And this basically comes back to, what is a legitimate expectation that the investor had at the time of when it was making this investment. And, basically the assumption is nothing will change. As an investor, nothing's going to change, which is a pretty ridiculous premise when you consider how, deep sea mining has never been done before. It's completely untested. We don't fully understand and know what the impacts will be. So to, make the projection that nothing will change is completely, I would argue, unrealistic when, of course, when you try new things, you have to respond and deal with that. And within this agreement, there's very little exceptions for Tonga and Nauru to actually be able to, work around this legitimate expectation right that they've given to the minerals company. The third one is expropriation. Pat touched on this. And again, it's this idea that, Tonga or Nauru can't do anything that the investor thinks will interfere with their ability to make a profit or what they were expecting to what they consider their rights. And so this is, gives them a huge amount of sway in challenging what governments are proposing, and sort of really will limit and inhibit what the regulatory options there will be for Tonga and Nauru, particularly if things go wrong. Sorry. Yep. The last two I just want to touch on. One is full security and protection. So the way that the contracts are worded gives a huge amount of rights and to the company and obligations to the government to protect them from any sort of legal challenge or threat. This includes domestic legal action. So if something that this investor has done has caused harm, then there's a real barrier to what domestic procedures that they or ways that they can be held account. Interestingly, this would also probably apply to international law, which is particularly important at the moment, where deep sea mining is currently being pushed ahead by the US outside of the International Seabed Authority. So outside of international law, companies like the Metals Company, with the support of Tonga and others, are essentially looking to unilaterally just go it alone and start mining in the high seas area. And that basically puts Tonga in direct conflict with international law. And so what does this mean under this contract for Tonga's role as a sponsoring state? And the final one, and I think this has been touched on previously, but is around the chilling effect. So all of these rights given to the companies basically set them up to have that leverage to come in and say to Tonga, to Nauru, to anyone else, if you do this, then we might bring a case against you. And that, for a country like Tonga that's, has debt issues, has limited ability to raise government revenue, that's a huge threat. Like that's a real practical and destructive threat to make. And so that will have a huge impact on the willingness and the boldness of any of these governments to really regulate heavily an industry that is, still being, hopefully doesn't start, but if it does, it's still being worked out. And so for the Pacific, like I was saying, deep sea mining in particular is untested and dangerous, and there will almost certainly be regulatory responses. And so under the way it's being currently established through these contracts and the ISDS and components within them, this will only happen, this ability to regulate will only happen at great cost, or it just won't happen. And that's sort of the what's being faced by these governments at the moment. And just to sort of flag, to reiterate what Kyla was saying around, whilst there might not be a lot of Pacific Island countries who are exposed to ISDS through investment treaties, the role of ISDS in stopping, real action on climate change or, trying to keep emissions, to stop emissions, that's putting the Pacific Islands at risk. So they have a stake in that, even if they're not directly on the hook for it. Conscious of time, so I'll wrap it up there and hand on to India, our next speaker. But yeah, thank you once again for having Pang and me sort of to speak on this.
Thanks very much, Adam. Our final speaker is India Logan-Riley, who's the project manager for Tai Tawhito Tai Tipua, a project developing a framework for climate justice, emancipatory economics, and constitutional transformation, grounded in Te Tiriti or Waitangi, which is the Waitangi Treaty with Māori, young people, unions, and frontline communities. So over to you, India.
Firstly, thank you for having me. Lovely to speak alongside these other folks who are doing such important work. My previous job was at Pang, so it's lovely to see Adam and hear from Adam as well. Yeah, big ups to the Pang team. They're doing incredible work. First of all, I don't have a fancy PowerPoint. I'm preserving my internet just for talking to you, but I will share a link to a report that the entity that I sit on recently published about ISDS, so you can get all the more detailed notes in that at the end of this webinar. And I mean, it's already been spoken about, but I do want to take us back to the roots of ISDS in terms of a colonial tool to maintain the extraction of profits, or maintain the extraction of super profits, really, from resource extraction and infrastructure projects. And that being a core way in which then the whole structure was designed is deeply inaccessible to Indigenous peoples, the whole ISDS process, the access to the courts. There are several layers in which it continues to perpetuate injustice against Indigenous peoples. What I will say is like a little nuance to that picture, right? Which is that historically ISDS is for pinning down developing countries who've entered independence in order to be able to maintain the extraction of those profits for wealthier countries and Western corporations. Is that, of course, as we heard about, that the ISDS process is being used to maintain extraction of fossil fuels in wealthy countries as well, and to stop the just transition too. And so I think we're just seeing the nature and the shape of that structure shapeshift so that they can continue to maintain the status quo. And, you know, it'll come for everyone and anyone at some point. So watch out for ISDS. But I want to firstly affirm that the investor-state dispute settlement process is not a reflection of Indigenous legal processes as well, and that's something that's really important to understand, is they're a reflection of colonial legal structures. And so even to the degree that, you know, it's secret, that these hearings are heard under secrecy, that we don't even know what's happening in them, we don't know when they're brought by the companies, is a breach of Indigenous legal processes. And so when we're thinking about what is Indigenous justice in these spaces, it goes from free trade agreements all the way across to even how we design accountability for these corporations. I am going to use the Aotearoa context throughout this, throughout what I'm sharing, but, you know, of course, it is broadly applicable across colonial contexts because, like, the colonial playbook was the same around the world, and so we can draw learnings across the board. And the kind of the most important part to understand about free trade agreements broadly, and then, of course, ISDS within that, is that what we have is colonial powers conveying sovereign-esque powers to an external entity without the consent of the Indigenous population. And so in terms of Aotearoa, you know, Māori, we signed a treaty with the British Empire that was not upheld and continues to not be upheld, continues to be breached. But then that settler colony of the New Zealand government has decided to then convey powers over to corporations to be able to have kind of play a sovereign and legislative restriction role on the colonial government. And so what we have there is a settler colony, which is in breach of the treaty here in Aotearoa, then extending that breach by giving the authority, conveying the authority over to other corporations as well. And that continues to be the case even for free trade agreements, right? For the New Zealand government to enter into free trade agreements without even the bare minimum of free, prior, and informed consent is a breach of that treaty. And not only is it a breach of the Treaty of Waitangi, it's also a breach of, you know, those other Indigenous rights, best practice standards such as the UN Declaration of the Rights of Indigenous Peoples and those kinds of instruments as well, right, which enshrine Indigenous people's right to be self-governing, to make decisions for ourselves, to choose our own representation, and to enter into treaties on our own terms. And instead, we have governments in countries across the board where there are Indigenous populations where treaties, free trade agreements, are being entered into without our consent. And so I think, you know, as I talked about, there was this example of an ISDS, no one has access to it, but as Indigenous peoples, we also don't have access to that space, even though it's talking about what's happening in our own backyard. And so And there have been examples of Indigenous peoples trying to say, hey, we actually should have a seat at the table in these processes. We should also be part of the discussion when it comes to corporations bringing these claims. But then having those private courts decide that Indigenous peoples don't belong in that space because they come under the umbrella of the colonial government, and they're not independent enough to be worthy of a seat at the table. And that particularly came through in a decision that involved the Zimbabwean government and Indigenous communities. And so both a colonial government and a corporation can shut Indigenous people out, even though, like as we heard about in some of the previous examples, there's Indigenous territories that get screwed over and destroyed by these corporations. And there's a particular example I want to point to where even if a country is found in favor of in the ISDS process, that whatever compensation is accrued from that and paid to the country, that money doesn't make it back to the Indigenous peoples who've been most directly harmed by that corporate behavior, right? And so there's an example of this in Ecuador with Burlington Resources, who sued Ecuador for damages. Ecuador then countersued. They managed to get some tens of millions, barely anything, but none of that money then made it back to the Indigenous communities who are being directly harmed. And so there's an interplay of power happening there that the ISDS process ends up exacerbating. And of course, in the context of the New Zealand government, and you may hear this in ISDS spaces and or even in free trade agreement spaces, and so I just want to kind of say hey to flag it, is that historically New Zealand government has put in what's called a treaty protection clause. And what it basically allows for is that the New Zealand government is allowed to make some decisions in favour of Māori at a local legislative level. It's still open to being challenged through an ISDS process. So those private courts, those hidden secret courts, can still challenge the interpretation of the treaty that the New Zealand government is making. So the Crown can then be challenged and then be forced to change its application of the treaty without Indigenous people's consent, who are the other party to that treaty. And so even though there is that slim protection clause in there, it doesn't actually protect us from the negative impacts of ISDS. And that also can only really be applied to protecting Māori people in quite a narrow sense. If we as Māori and our legal authority decide to push for a law change that would protect the environment, that would protect our people, that would bring back healthcare into our control and that kind of thing in a way that disrupts profits, that could also be challenged, but would sit outside of the treaty protection clause. So much of our sovereignty is up for fair game and undermining, even though that is our right to exercise and to decide. Now, the thing is that New Zealand has said that they will no longer sign agreements that has ISDS in it since 2017. So little win there, but it still remains in several bilateral, multilateral agreements that New Zealand is party to and signed before that change was made. So we're still trapped by that in many ways. And that was one of kind of the key reasons that it was such a big resistance to the Trans-Pacific Partnership Agreement in the 2010s, was because of what it would mean for Indigenous governance, and then also by extension, of course, the chilling effect on climate legislation as well. And so, yeah, there's many layers to that, but I think it's helpful to couch ISDS within, the broader understanding of what colonial governments are doing when they enter into free trade agreements writ large as well, which is that abuse and that override of our sovereign autonomy and our rights as well. But that's it from me. We'll have your questions next, I think. But yeah, happy to answer any questions then. Kia ora.
Okay, thanks very much, India.